Right, so where are we? We are straightening up the camera. Is that straight? Hopefully it is. This is still not fucking straight. If you're serious about property investment, you have to be serious about due diligence. Good due diligence will make you look lucky. Bad due diligence will make you feel like a fool and you'll be throwing away money. If you're interested in property investment, I drop a lot of advice in this video. I know it's a long one, but make sure you stay watching to the very end. Due diligence. What is it? It's an investigation or an exercise of care that a reasonable person or business would undertake before entering into a contract or agreement with another party. This video follows on from a recent video I did on property gurus, but I'm going to focus this video on due diligence in regards to what it is, why it's important, and why you should learn about it. I'm also going to share some mistakes that I have made in the past to make sure you don't make those same mistakes, so stay watching to the very end. Proper due diligence involves knowing where to look, knowing who to ask, knowing how to verify those answers. Due diligence can be split up into four main sections when acquiring a property: your valuation due diligence, your legal due diligence, your structural due diligence, and also your covenant due diligence. You should strive to understand each element on your journey to become an expert property investor. So know who to ask. You will have to rely on a range of professionals when you're acquiring an investment property, from your solicitor to your agent to your architect to your contractor and your QS. These are all people you will have to rely on, and it's important you know and understand the advice that they're giving you, as you are the decision maker and you're the one at the end of the day who will have to make the ultimate decision on acquiring the property or walking away. Valuation due diligence. Remember, a sales agent is not acting on your behalf when you're acquiring a property. They're acting on the vendor's behalf. Therefore, it's always advisable to engage a separate valuer to act on your behalf when you're acquiring commercial or investment property. If you do engage a valuer or an agent to act on your behalf when you're acquiring an investment property, they will not only be able to advise on value, they'll also be able to advise you on the marketability of the property in terms of a letting point of view, and also be able to advise on any current lease terms that might actually affect the future value of the property. Legal due diligence. A good property investor will always stay up to date with any legislation changes that could impact the value of their property. Understanding leases, both commercial and residential, are a key element of becoming a good property investor. Understanding commercial leases can actually open up opportunities for a good investor. Try carry out as much legal due diligence before placing a bid on a property as possible. The asset being sold and the method of sale will actually determine how much legal information you receive prior to being able to put in a bid. If the property is being sold by auction, the likelihood is a full legal pack will be available before the auction. Your solicitor should always review this full legal pack in detail before you attend the auction or before you place a bid. If your bid is accepted at an auction, you are tied into a contract, and you are also tied into any issues that are involved in that property that you may have missed during your due diligence. Therefore, auctions bring an element of risk, and historically they've never achieved the best price for the seller. If the sale is by private treaty or similar, generally speaking, all leases will be available to review. However, a full legal pack may not be available during the marketing process. All leases should be reviewed in detail before placing a bid. I'll cover this off in more detail later on in the video, but it's important to review all leases before you place a bid. Once your bid has been accepted at private treaty or similar, your solicitor will then be able to review the full legal pack in detail, and if there are any issues that your solicitor becomes aware of, they can inform you and correctly advise you on those issues. They'll also advise you if those issues could impact the future sale or saleability of the property in the future, and that could have an impact on the value. So it's at this point you have an opportunity to walk away or continue on with the sale. Due diligence is also knowing how to understand the advice you're given and test it as well. There will be certain times where your solicitor will advise against a certain acquisition, but you may need to make a commercial decision. But if you are not experienced enough to make that commercial decision, I would always suggest going with your solicitor's advice. As you gain in experience, you will be able to understand these legal issues and how to solve some of these legal issues, as well as how long it will take to resolve and the costs involved. And you'll be able to build this into your bid and your valuation. Structural due diligence. Your building surveyor should be able to advise you on any structural issues, as well as the costs involved in remedying those structural issues. Your architect will advise you on any planning issues, as well as any development potential. I will be creating a video on development appraisals shortly, and I'll include all the elements that you should include in your due diligence when you're looking at sites and developments. Covenant due diligence. So here's why it's so important to understand leases and commercial leases. Investment property value is underpinned by a lease, the covenant strength of the tenant, as well as the future ability to rent a property. The covenant strength refers to the tenant's financial ability to pay the rent. When looking at a commercial investment property, the covenant strength and the lease can have a huge impact on the value of that property. The covenant strength needs to be considered within different industries, from hotel, office, retail and warehousing. No two tenants are the same. A tech startup is not the same as an established accountancy firm that has been around for hundreds of years. A valuer will put a higher covenant strength on a well-established firm. A quick note of caution here, actually, it's important to be mindful that large companies can sometimes use smaller subsidiaries to take leaseholds on properties, and this mitigates any risk, but the smaller companies may not, or these subsidiaries may not actually have any assets, and the covenant strength could be very weak. So as I said, covenant strength can have a big impact on value. So just a quick example here. So assume we take two office tenants. They've both taken two identical leases in adjoining buildings. Same 25-year lease with 5-year rent review patterns. Building 1 is leased to an established accountancy firm that has been around for 100 years and has 200 employees and pays a rent of $300,000 per annum. Building 2 is leased to a new tech startup company that's been in existence for 3 years and has expanded to over 200 people in the last 6 months and is paying a rent of $325,000 per annum a year. So let's assume the market yield in the city for office space is currently 5.5%. The accountancy firm is a well-established business, been around 100 years and is unlikely to disappear in the next 20 years, and therefore the rent and cash flow from that tenant is pretty secure. A valuer will likely look at this as very secure tenant and will apply a discount to the yield. So they could knock off 0.25% or they could knock off 0.5%. So let's just say in a quick calculation they knock off 0.25%. So therefore you take a yield of 5.25%, apply it to the rent of 300,000. This would equate to a gross market value of 5.7 million for this building. The tech startup company has been around a few years. They've rapidly grown but they're yet to show a profit. There may be a risk that they could continue to grow out of the space or detract and not need the space anymore or be acquired by someone else. So the long-term future of their rent is not that secure, even though they're there for 20 years, but their history has not been established. A valuer will probably apply a higher yield to this lease. So they will likely apply maybe 0.5% or a full percent extra. So they could apply 6% or 6.5%. Let's apply a yield, say, of 6.25% to their rent of 325,000. This would equate to a gross market value of the building of 5.2 million. So therefore you can actually see the difference that the covenant strength has made here in terms of the value. One building is actually producing a higher rent than the other, but because a tenant is slightly weaker, the actual value of that building is lower. This just illustrates the importance of covenant strength and the impact it can have on value. In this example, I've assumed that both leases are the same. However, that's not the case in reality. Generally speaking, leases differ vastly, and they can have a vast impact on the value of a property as well. So I'm going to explain now what the important clauses to look out for within leases, so you know when you're reading a lease what will have the biggest impact on the value. Most commercial leases are about 50 pages or maybe 100 pages, but I have seen leases that are 300 pages long. So it's important to get to understand how to read them, and it's important that your solicitors are going through them in detail before you put in any bids on an investment property. The main clauses to look out for within a commercial lease, the first one is actually who are the tenants. Are they the company that are actually there, or are they a subsidiary of a much larger company? So it's important to know who's actually on the lease. If it is a subsidiary of a larger company, has the larger company provided a guarantee on the lease as well? The next thing to look out for is the lease term. In commercial leases, lease terms range from 20 years to 10 years to 5 years. But it's important to know how long is left on the lease, because this basically states how long your rental income is guaranteed for. You should also check the headline rent to make sure that the actual tenant is currently paying the headline rent and that there's been no abatements. But actually something in regards to lease term that actually frustrates me quite a lot, I'm not quite sure why they're still out there. In my mind they should be a thing of the past, but is 4-year 9-month leases. So these were a thing that were done in the past to make sure tenants didn't get rights for renewal, because after 5 years a tenant got rights for renewal. This is an important thing to know, because if you see a lease, if you're reviewing a lease on a property and it's a 4-year 9-month lease, it's important to understand that that's the first 4-year 9-month lease the tenant has got, because if it's their second or third, the tenant has rights and that lease may as well be a 20-year lease. But I can't for the life of me understand what solicitors or what agents are still out there recommending that 4-year 9-month leases should be still entered into. In my mind, they're a thing of the past ever since tenants could contract out their rights via a deed of renunciation. I'll pop a link into the description to explain what a deed of renunciation is, but it's effectively a contract where a tenant contracts out of their rights for renewal after 5 years. So this means a landlord has much more flexibility to give a tenant a longer lease, and it does away with this whole need for a 4-year 9-month lease. In my mind, they should be gone a long time ago, but be careful when you see them, because if it's not the first one, the tenant has rights already. But actually speaking about deed of renunciations, it's also important that you actually check that a tenant has signed a deed of renunciation and is attached to the lease when you are acquiring a property. Rent review clauses are a very important part of commercial leases. Since February 2010, upward only rent reviews have been banned here in Ireland. This basically means that a landlord cannot put in an upward only rent review clause into a lease. But it does mean that any lease prior to 2010 probably does have this clause, and it's important to know, because you may be buying a property that is over rented if the lease was entered into before 2010. Just something to bear in mind when you are calculating your investment for the future, because you may be actually buying an over rented property. It's important to understand within a rent review clause how a rent review is triggered and when. Most commercial leases allow for a rent review every 5 years, and generally speaking a rent review clause within a lease can be anywhere between kind of 4 to 6 pages. But these 4 to 6 pages can have an absolute massive impact on your value of your commercial investment. So much so that I actually have 2 books here that are huge complicated books that go into all the different scenarios that can happen because of a break. Options are actually getting more and more common within commercial leases. Generally speaking, if a lease is 20 years, it may have a tenant break option in year 10 or sometimes in year 5. They sometimes come with penalties if a tenant breaks early. There's generally speaking the notice period is quite strict on this, But it's something for you to be very mindful when you are buying an investment property, that if a tenant has a break option, you need to build it into your calculations for valuing the property, because it could mean a break in your income stream. As an investor in commercial real estate, it's important to understand that some of your costs can be passed on to the tenant. Generally speaking, these costs include service charge and insurance, as well as sometimes the ability to pass on any legal costs that may be occurred because your tenant has broken one of their lease covenants. The repair clause is also a very important clause to understand. It's important to understand who is responsible for repairing the property. Is the tenant in a commercial property responsible for full structural repair, or are they responsible for internal repair only? Because this is an important factor to build into your cost and build into your valuation. It's also important for an investor to check the user clause within a lease before they buy a property. The user clause basically states what the tenant is allowed to use the property for. The investor should also investigate, does the tenant have planning permission for what they're using the property for? Because if they don't, it could have a huge impact on the value of the property. So it's always important to check these things before you put a bid on the property. So in terms of residential, it's actually, due diligence is quite a lot easier in terms of residential leases. Generally speaking, they're only about 10 to 20 pages. The main things to check are the lease date, who's actually on the lease, are they paying the correct rent, when was the rent last reviewed, and also that if the lease is registered with the PRTB. If a property is vacant, it's also important to see if the rental pressure cap of 4% applies. If the property has never been rented before, that cap does not apply. But if the property has been rented before, there could be a rental cap on the property. So it's important to check this before you put a bid on a property. Your solicitor in terms of residential will check that the property taxes have been paid and the non-principal private resident tax has been paid. They'll also get any service charge details as well as any sinking fund if there's a management company in place. Tax due diligence is also an important element, but it will depend on who you're acquiring the property from and what entity you're actually acquiring the property through. So I've actually said it plenty of times before in other videos, but the best way to learn is by your mistakes. But hopefully maybe I might be able to give you 2 mistakes here and you'll be able to learn from mine. But making mistakes in property can actually cost you a fortune, so it is good to learn from others as well. One mistake that actually sticks in my mind and has stuck in my mind for a long time is back in 2007, 2008, put up a development site for sale. The site had planning permission for 10 houses. So we achieved the price we were looking for and we moved to legals. In legals, we actually discovered that there was a planning condition that restricted any development on the site until development on another site within the local area had commenced. However, this other site had nothing to do with the subject site in question. I approached the council to see if they would remove this condition from the planning permission so we could go on and sell this actually site. The council admitted to me over the phone that the condition was an error, and it was a copy and paste error. However, they were only willing to admit it over the phone to me. However, what happened was in 2008 the crash happened and the sale fell through. However, due to this mistake, I learned early in my career that planning documents are very important and they form part of good due diligence. A more recent mistake, last year I had an opportunity to get involved in another business. I did my due diligence at the start. I had some concerns and there was some flags that were thrown up. My legal advisor reviewed the contracts and advised that I should in no way, shape or form sign these contracts. However, I was made to understand that there would be some movement on the contracts and I decided to work away and see if we could get this opportunity up off the ground. However, after 9 months, there was no movement on the legal contracts and we were still as far away as we were at the outset. So after 9 months, I had to take the decision to walk away and decide that it was no longer the best opportunity for me. At the time, I was so disappointed that I'd wasted 9 months on this opportunity when clearly I had concerns from the outset. 9 months of due diligence has probably likely saved me a whole world of pain. My mistake here actually was not listening to the advice I was given and trusting in the team I have around me. Basically, I knew there was issues. I also was advised, I had legal advice telling me not to go ahead, but I let my emotions play a bigger part of making a decision here rather than actually following the correct legal advice. So in summary, due diligence can make or break a property investment. Poor due diligence can mean a costly mistake. So it's an important skill to learn. Know what to look for. Know what to look for from a planning point of view, from a legal point of view, and from a valuation point of view, as well as a structural and development point of view. Know who to ask and know who to trust. The best piece of advice I can give you is actually build a team around you of trusted advisor from solicitors, agents, quantity surveyors, architects, and contractors. That's the best piece of advice I can give any property investor. Build a trusted team around you. The next piece of advice I can give any property investor is become a good problem solver. Property will throw up lots of different problems, but what will actually separate you from a good investor to an amazing investor is how you can solve those problems. If you have any questions on due diligence, put them in the comments below or DM me on Instagram. The next video is going to be on discounted cash flow valuation. 1 or 2 students reached out and asked if I could do a quick video, explainer video on discounted cash flow, which I will be doing in a few days. So make sure you subscribe and hit that ring notification bell. Until next time, thanks for watching and stay healthy and safe.